Wickham. I'm a legal executive in our dispute resolution team. One of my expertise is debt recovery, and I oversee our debt recovery team. Here at Ashton's Legal, we have a dedicated debt recovery team who assist businesses and individuals to recover debts of various sizes from third parties. In most cases, we can assist under our fixed fee debt recovery service. So we offer a fixed fee debt recovery service to provide opportunities for businesses and individuals to recover their unpaid debts. We fix our fees depending on the value of the debt itself. The fixed fee debt recovery service is aimed at more straightforward debts, which usually arise as a result of unpaid invoices from contracts for the sale of goods or the supply of services. Where debts are more complicated in nature, for example arising out of loans or leases, or where debts are disputed, we charge in our usual way on an hourly rate basis, and we will provide you with a fee estimate for that service. The first step in all debt recovery is to send an initial compliant letter for action to the debtor. Where a debtor is an individual, we have to comply with the pre-action protocol for debt claims. This requires us to allow the debtor to have 30 days to make payment of the debt or respond with a reply form. If they respond with a reply form, we have to give them a further 30 days to make payment before we can take any further steps, such as issuing court proceedings. Where a debtor is a business, we give them 14 days to make payment or respond to the letter for action. If a response is received to the letter for action, we generally try to reach an out-of-court settlement with them by way of negotiations to try and avoid the need for possible lengthy and costly court proceedings. However, in some instances, court proceedings are required. If court proceedings are required, then that will involve us preparing a claim form and particulars of claim and sending it to the court for issuing. Once a claim has been issued, the court usually send the paperwork to the debtor to serve it on them. The debtor then has 14 days from the date of service to respond. If no response is received to the claim, we can generally obtain judgment in default fairly quickly. However, if the defendant does file a defence to the claim, the court process will proceed to a final trial. Our team of experts can help and guide you through that court process. Unfortunately, if judgment is obtained, it doesn't guarantee that payment will be received. If payment isn't received, the next step will be to take enforcement action. There are various methods available to enforce a judgment debt. The most popular method used by creditors is to instruct the bailiffs or the High Court enforcement officers to obtain a writ or warrant of control. However, there are other methods also available, which include applying for an attachment of earnings order, a charging order, or a third-party debt order. We can advise you on which method is most appropriate depending on the debtor's circumstances. The general position is that the winning party can recover their legal costs from the losing party. The amount of costs that can be recovered will vary depending on which track the claim is allocated to. There are 4 tracks, which include the small claims track, the fast track, the intermediate track, and the multi-track. The track is essentially the process that the claim will follow up to final trial. Where the value of a debt is up to £10,000, the claim is usually allocated to the small claims track, which is generally described as a cost-free environment. This means that neither party can recover their legal costs from the other side, even if they are successful, save for very limited fixed costs for issuing court proceedings. Where a debt is between £10,000 and £100,000, costs are recoverable. However, they are subject to a fixed cost regime, and the amount of costs that can be recovered will be dependent on whether the claim is allocated to the fast track or the intermediate track, and which complexity bands the claim is allocated to by the court. Where a value of a debt is over £100,000, it will be allocated to the multi-track, which is not subject to fixed costs. The creditor can usually expect to recover between 50 to 70% of their legal costs from the losing party. This does, however, create more risk involved in pursuing claims over £100,000 because if the creditor is not successful with their claim, they are at risk of paying the debtor's legal costs in addition to their own. recovery team are here to assist you or your business with any debt recovery claims. If you require any assistance, our contact details are on the website. Please do not hesitate to contact us.